For our panel 6 discussion, the Privacy Risk Framework, a risk-based approach to privacy, we have David Smith, Deputy Commissioner and Director of Data Protection in the United Kingdom, Willem de Boccolier, President of Privacy Commission Belgium, Jane Howard, Senior Director of Global Privacy, Apple, Mr. Eric Neuenschwander, Head of Privacy Engineering, Apple, Johan Stonier, Executive Vice President, Information Governance and Chief Privacy Officer, MasterCard, Isabelle Falk-Pierrotin, President of the Commission Informatique et Libertaire, and Article 29 Working Party. Our moderator today is Boyana Bellamy, President of the Center for Information Policy and Leadership at Hunton & Williams.
Good morning, ladies and gentlemen. Thank you for joining us. I want to show you this slide here and ask you, does anybody know where this has been taken, where this photo has been taken from? Maybe those of you in Mauritius may know. Ms. Mathoub, come on, you must know where this is. Okay, that's right. So this was a photograph that was taken very badly by me, I'm sorry about that, in Port Louis, which is the capital city of Mauritius. We were there on Monday afternoon, and there is a very nice commemorative stone that actually cites the Universal Declaration of Human Rights. It's on the waterfront to remember and remind everybody about the importance of human rights for this country. And there it says, and you can see it in not a perfect photograph, but it said there that no one shall be subject to arbitrary interference with his privacy, family, home, correspondence, nor the attacks upon his honor and reputation. And there is another sentence that isn't there. Everyone has right to protection of law against such interference. So I thought it would be really interesting to just remind ourselves what we are talking about here. And in fact, this ties very well to what you have heard in the previous panel. We talked about the privacies of life. Neil mentioned the Supreme Court Riley decision where privacies of life is being discussed. And what is this panel today? What we really want to talk about is how do we give meaning to privacy? What does it mean to protect privacy and data protection as a fundamental right? And what I'm going to hopefully show to you with the help of my wonderful panel is that we have got and we can develop tools that can all help us understand what this privacy is to be protected. What are the harms that we need to address? And all this is done in order to achieve effective compliance, which is really what we're talking about here. There was a lot of discussion about yesterday as well, Isabelle mentioned it and some others as well, Ms. Mathoub as well. How do we translate the concepts of privacy, fundamental rights into something that is practicable, implementable? How do we make sure it's effective on the ground? How do we make sure your role as data protection regulator is also effective on the ground? How do we make sure that organizations, and you've got some of the chief privacy officers, privacy engineers, translate this in a way that is effective and delivers effective compliance and effective prioritization as well for their companies as well? So let me then start on, and I just want to maybe kick off this panel explaining what I mean by risk. Christopher Graham famously said, the Information Commissioner UK, this is the R word, and we all mean different things by the R word. So what do I mean by risk? And hopefully you will share my views as well. And why is this privacy risk in? Why are we talking about this today? First of all, I really think it has always been in. Organizations have always been thinking about risks and risk assessments, but from now, they're going to be thinking about it in a different way. To date, it was always about risks to organizations. What is the risk to my company for not complying with data privacy law, for suffering a security breach? What is the reputational, legal, commercial, monetary risk? Now, we have to flip the coin, because this is the second side of the same medal. What is the risks to individuals? What are the harms that may be created from the processing, from the technology, from the system, innovation, information use that I'm doing in my organizations. It is risks to individuals rather than risks to organizations. That is what we are focusing here, and that is something new. It's a novel way of talking about risk. When we talk about harms and risks, I just want to make clear that my view is that these risks and harms are both material, tangible, but also non-tangible. They are risks to reputation, risks of stigmatization, risks of discrimination, fear, embarrassment, anxiety, etc., etc. And you have seen some of these examples that Adam Tanner gave. And that gives you an example of the types of risks that are really not material, but they're beyond material. And of course, some people talk about negative impact to individuals. The center has been using the word harm just to mean both tangible and non-tangible, but of course, we can talk about the negative impact on individual or what we are trying to do. The second reason why I believe the risk is really important, and we have to think about it, is and you have heard this again and again and again at this conference as well. Modern information age, the world of Internet of Things, big data, ubiquitous information, really requires us to evolve interpretation of privacy principles, implementation of privacy principles, and requires us to think of some innovative models of co-regulation and compliance. What do I mean by this? I'm not saying we should be repealing privacy laws and forgetting about privacy principles. In fact, I completely agree with what Edith Ramirez said yesterday, the chairman of FTC, and she repeated that privacy principles are solid, they're here to stay. The same thing was said by Article 29 in their big data statement recently, as well as the Information Commissioner's Office in, again, very good paper on big data. So privacy principles remain, they stay, but it's the implementation and interpretation of these principles that has to evolve to allow us to think about, as Marty has said, not privacy notice, but transparency. We need to evolve, we need to move. And this is where I believe risk can actually help us a lot. When I talk about co-regulation and innovative ways of compliance, again, I'm just echoing what Isabel, you have said yesterday. We really need new tools to put within the legal framework and on top of legal framework to ensure effective compliance. And these tools are the ones that will make sure that individuals are protected and companies know what they're doing as well. And these are accountability tools, the models like binding corporate rules, like APAC, cross-border privacy rules, and the referential that has been done. That's all great to hear. It was excellent to hear the Microsoft example of the cloud privacy standard. That is an accountability tool that is certified, verifiable, that company goes beyond and above compliance. Commissioner Alan Chang talked about that, beyond and above compliance, because it doesn't help you just to comply with the law. You're not going to actually execute what you need to execute internally. And of course, looking at the EU data protection regulation and what has been proposed there, there is a lot of reference to certifications, codes of conduct, privacy seals, and accountability. These are all the tools that really this innovative co-regulation and compliance is going to offer to us. I talked about this need to translate abstract goals of privacy and fundamental rights into something that people understand, and we're going to speak to some privacy engineers here who are going to tell us how you do that. It's not good enough to tell your board and your privacy engineers we have to protect privacy. What is that we have to protect, and how do we do it? That's what risk is going to help us determine as well. And then finally, risk, and to reiterate this, risk-based approach really, in my opinion, and I think you will all agree with me, does not replace existing law, doesn't replace privacy principles, doesn't replace the supervision that you as privacy regulators do. It doesn't replace the accountability models organizations do at all. It is just calibrates the compliance. It calibrates, allows us all, regulators and companies, to calibrate the way we behave based on the risks and harms to individuals. And what is important for this is context, what sort of data, what type of processing, and you've seen all of these examples at this conference. What's the severity of this risk and harm? What's the likelihood? And these are the things we have to think about. And then finally, just to remind everybody, so you don't think we are building some castles in the air, today, Risk assessment is already a legal obligation. From New Zealand to Canada, to the new EU data protection regulation, to the FTC enforcement actions, risk assessment is a requirement of today. It is also a requirement of accountability, and I will show to you, hopefully, also what I mean by how organizations actually implement accountability based on risk assessment. Just some examples of legal obligations. Everybody knows about security. How you determine security measures is going to be always based on risks and harms. Whether you notify data breach is going to be determined on the harm that you create to individuals. Legitimate interest, this amazing and great example of legitimizing processing without individuals. The risk assessment is critical there in order to allow you to balance the interests that you have in processing data and not prejudicing personal rights and individuals' freedoms and rights. You have to think about the harms and risks to individuals. And it is everywhere. So what I'm trying to say, it is already there today as a legal obligation. So very quickly now, just to reiterate, I really think there are huge benefits of risk-based approach, the way I have explained it, not as an alternative, but as an add-on, because it delivers effectiveness. Effectiveness, for me, is the key word. This is what we are all striving to do. This is what the organizations and boards want to know. They want to know that the money they're putting in their compliance efforts delivers effective program. Dale Skivington talked yesterday about the compliance programs she developed at Dell, and that is exactly what boards want to know. All these efforts that go into compliance really are effectively protecting privacy of individuals and determining and mitigating risks to organizations as well. It helps prioritize, it helps give some predictability as well. For regulators, I think it is important as well. It helps them, and I have to quote Richard Thomas. He is not here, but Richard Thomas would have said, selective to be effective. And I know that in the world where everybody is strapped for resources, we all have to be selective to be effective. You have to address issues that Adam Tanner talked about. That is the role. That is what I, as citizen, expect from you as data protection regulator. And Jakob, I don't know how we do that, but that's what regulators have to do. They have to address the areas where there's the biggest harm and risks to privacy of individual, my privacy, both tangible and non-tangible distress as well. I think there is also benefit for lawmakers. It is important that we create rules and regulations that will stand the test of time, that are flexible enough to adapt to the outcomes and context. And then finally, it helps the individual hugely as well, because it is the individual who we're trying to protect. It's not some data. They really want to, they have concerns, they worry the creepy factor. By addressing the risks up front, you avoid the creepy factor. And of course, I do have propensity to think big and to be optimistic. I really think that if we agree and have a consensus around harms and risks, and what we should be focusing on, both organizationally and as regulators, I think we are going to be converging. We are going to be creating some form of common expectations, common best practices, and common outcomes in this world that is one world of privacy, but it is still diverging, I'm afraid. And finally, I want to remind everybody how risk assessment is a concept and element of accountability. What I'm showing you here is, if you like, the agreed world, agreed notion of what accountability, what privacy compliance program, what effective compliance looks like, and most organizations base their compliance programs on this way. And this is something that has been picked up by a number of laws. Mexico talks about it. EU regulation is picking up accountability. Hong Kong Privacy Management Program guidance, of course, Canadian privacy framework as well has got the same elements of accountability, and risk assessment is there very, very firmly. What do I mean by that? And this is my last slide. How does organization take risk assessment to calibrate and adopt compliance program? And in my view, there are two ways you do that. At programmatic level, in order to decide what's your program, right, what is this going to look like, you have to be understanding what risks and harms you are creating to the society, individuals, etc. So you're going to decide what the program looks like based on risk and the harms to individuals. You are then also going to conduct periodic program assessments risk assessments based on risks and harms, because this changes. From now on, you're moving to another area, you're going into big data analytics, so the risks and harms that you may create are going to be different. Your program has to be adapted to that. And of course, each of these elements